Please welcome Marty Kropelnicki, President and CEO of California Water Services Group.
All right, good afternoon, everyone. It's great to see everyone. Jim, as you were giving a little bit of history of the Bay Area Council, I realized it was 10 years ago this fall. This guy, Jim Wonderman, invited me to lunch, and I thought, who in the heck is this guy, Jim Wonderman? But it's probably a free lunch. And we've enjoyed 10 great years with the Bay Area Council and work with them on a lot of environmental initiatives. And it really is a great organization that does outstanding work. And we're very honored to be here today and participating. I want to start with a quote my grandfather used to give me. And I thought about, should I use this or shouldn't I? But I think it's important. I think it gets to the next panel discussion we're having. My grandfather was an immigrant, came from the Ukraine. And as a very young boy, he used to quote Dr. Martin Luther King, which is pretty profound, someone from halfway across the world quoting Dr. Martin Luther King and the concept of justice. And the quote was, "True peace is not merely absence of tension, it's the presence of justice." And as I've gotten older, I've come to really appreciate that quote and what my grandfather was trying to teach me, coming from a country that didn't have a good justice system. And I think they're going through those struggles today. So turn on the news, read the newspaper, all eyes are on Lady Justice and what's happening, from the controversial decisions handed down by the U.S. Supreme Court, as well as the greater public focus on racial and social justice, election integrity, and basically the historic foundation of our overall system of justice. Add in the pandemic and the switch to a virtual workforce that we're all living through, and that's put additional strains on the courts for speedy and equitable administration of justice for our society. Our court system usually operates in relative obscurity, but key rulings remind us that they have an effect on our daily lives for ourselves and our families. We've recently seen this when the California Supreme Court upheld a lower court ruling that threatened to block the admission of thousands of students to UC Berkeley. And a case that's now before the state Supreme Court that could decide the fate of billions of dollars in funding that Bay Area voters approved in 2018, which is an initiative that Cal Water supported. To give us some insight into the workings of the state Supreme Court, and to share her thoughts on the recent U.S. Supreme Court rulings and many of the questions that have emerged about the administration of justice in our country, we're honored to welcome California Supreme Court Chief Justice Tani Cantil-Sakaue. Ms. Sakaue was appointed Chief Justice by Arnold Schwarzenegger. She's the first Filipino-American and second woman to serve in this position. She's been a leader in reforming our bail system, and she's been a strong advocate for addressing the chronic underfunding that plagues our courts today. Leading our discussion today is Christina Lawson, Managing Partner and CEO of Hanson Bridget. Hanson Bridget is very much a very well-respected law firm. They've represented Cal Water on labor issues for in excess of 30 years. She's a former mayor of Walnut Creek, serves as president of the California Medical Board, and is a member of the council's executive committee. Please join me in welcoming our Chief Justice and Ms. Lawson up to the stage. Thank you.
Well, it's certainly a privilege and an honor for me to be here as the managing partner of a law firm. Of course, issues in the courts and the judiciary are top of mind for our organization and for me every day. But as Marty just referenced, they've become top of mind for so many of you, right? With the federal judiciary, of course, and courts in the spotlight most prominently. But these issues, I think, have a new prominence that perhaps they didn't have in years prior. So the first question, though, is one really about process, because there's, of course, the saying that justice delayed is justice denied. And as Marty referenced with the pandemic, the processes in the courts, both at the California Supreme Court and the courts throughout California, have been marked by backlogs and delays. I'm curious, from your perspective, how is this affecting cases before the California Supreme Court, and what are your thoughts about catching up?
Well, thank you. It's a pleasure to be here. I appreciate the invite to talk about one of my favorite subjects, the judicial branch of government. I do want to say yes, backlogs, both at the state level in every single state in the United States, at the federal level, have been exacerbated, if they once existed, as a result of the 2.5-year COVID pandemic. Courts across the country, California no exception, sought to shrink our footprint and to ensure that courts, which are just normally vibrant places of human life, actually shut down certain disciplines, certain courtrooms, went remote, turned on a dime in order to ensure that we didn't become super spreaders. And remember, courts are very often connected to jails and prisons. And we have the public, we have staff, we have the attorneys, and we endeavor to ensure that people, especially at the beginning of the pandemic, weren't dying from being in court. And also, remember, at the time in 2020, Governor Newsom issued a shelter-in-place order. London Breed, our mayor of San Francisco, did it first. This meant that you had to stay in place. There were state orders, there were county orders across 58 counties of California. And courts, as an essential business, we stayed open as an essential service. And as a result, there was a backlog. But at the same time, with the backlog, we ensured remote wherever we could. So a lot of civil backlog actually erased. It went away from even previous years. These are family law cases, dependency, delinquency, where we found a more willing population to do remote. Children, their parents, people from out of state. However, the backlog persisted. It grew after 2.5 years of being remote. Every now court in California in the 58 counties is open, including the courts of appeal and the Supreme Court. But I would say this, and that is we have a backlog, but only in two kinds of disciplines and only in certain courts. Only in complex civil, or unlimited civil, as you may know, probably where your cases are, and then also in felonies. And yet, at the same time, I have employed retired judges from across the state to work in civil and criminal backlog. We have gone to the governor on 2 separate occasions in our 2 sister branches of government to provide us millions in backlog funding that we can put these cases forward. Not every county has a backlog, in fact, but we are slowly chipping away at that, making all of our resources available. Civil judges who only do civil are now finding themselves trying misdemeanors and felonies. It is all hands on deck. And we also saw a reduction in filings. When law enforcement also didn't have a lot of people on the streets, there were fewer arrests, fewer citations, businesses were closed, and so we just didn't see the same number of about 6 million filings per year. But we're not unique, but we have everyone working, and we are working with the attorneys and all the stakeholders to try to find a way, if we can, to resolve the case prior to trial.
And is the California Supreme Court still conducting some of its hearings on Zoom virtually?
All of our hearings ever since March or April 2020 have been remote. And at first, we received pushback from the attorneys, but we have a day of practice. We walk through. We're pretty forgiving. We have breakdowns like everyone else, but we end up finding our way through.
So on to perhaps a more provocative topic. Of course, recent rulings in the United States Supreme Court on women's reproductive rights, in particular, gun control in particular, and others, have sparked really deep questions and much debate about the U.S. Supreme Court's impartiality. But federal judges, of course, have always been chosen through a political process, if you will. I'm curious about whether you think the process overall has become more ideological, more political, and what do you think that means for the impartial administration of justice?
Well, just as you said, federal judges are lifetime appointments, and if you will, the vetting and the front-loading occur well before the appointment, whereas state Supreme Court justices and Court of Appeal justices and Superior Court judges in California have an entirely vetting process that is different, and we have not term limits, but we are only elected or retained to certain terms. Now, the question is really, is it more political? I honestly do not know that, except to say that media, social media, the TV, the investigative practices, the ability, the scope, has certainly made it broader, deeper, of more interest to people. But I would also say, I remember when I was just an attorney, I was galvanized by Clarence Thomas's hearing, and I was in Mexico on vacation, and I'm watching it from a bodega TV. So for some of us, it's always been something we've been interested in. We found our way to it. We found our way for the interest. And it has always seemed, it is the president's with the Senate's privilege to pick, just like it is the governor's privilege to pick. It is a privilege of earning office. And is it more political? Well, with more people involved, with more comments, it certainly feels that way.
Assuming that these recent decisions on reproductive rights and gun control in particular have meant or signaled a shift at the federal level to really endow states with greater authority, the states' rights versus, federal rights. Do you see the state courts playing an increasingly bigger role in the administration of justice?
Well, let me just say that the national studies show that state courts handle 95% of the litigation in the United States, period. It is true that the federal courts, under the federal constitution and congressional acts, have a whole different array of legal discipline. But it is the state courts that have far more legal array of disciplines, which is why we churn so many cases. What we're seeing with this court, at least in the most recent, if you want to talk about Dobbs, is you're seeing a return to state court control, a return to state court. Certainly, it is an evisceration of a heretofore 50-year-old constitutional right that some of us thought we grew up with. But at the same time, the right has been returned to the people, really directly to the people and to the state. California's Constitution has always had a right of privacy, which we have interpreted as a medical right, which we have interpreted as a right to terminate a pregnancy. Other states as well. But really, it's a call for local leadership. It's a call for young people to run for office. It's a call for you to be part of your Constitution. Sometimes smart lawyers bring litigation under only their Constitution. They try to avoid federal court. I know there is a movement now. There's more litigation. There's more bills being considered for purposes of women's rights and privacy and gun control. And the state courts will hear that because now those will be crafted under the California Constitution or the state's Constitution. But recall that Dobbs took away and overturned Roe because Roe was premised on the Bill of Rights, some constitutional Bill of Rights amendments. They took that away. And so that doesn't mean that there aren't other grounds statutorily through Congress to be able to revive that. It just wouldn't have a statutory Bill of Rights constitutional tethering basis.
Yeah, one of the most interesting things about perhaps the past 6 months, just as an observer of the U.S. Supreme Court, has been the unprecedented leak of the Dobbs decision, or the draft Dobbs decision, right, which pulled back the curtain on the United States Supreme Court's really internal deliberative process. I'm curious if you could pull back that curtain a little bit for us on the California Supreme Court's internal deliberative process. How does it work behind the scenes?
It works behind the scenes primarily through the written word. We are 7 people, and we talk quite a bit with each other, and our teams of attorneys talk with each other. But at the same time, on any given case, I'm working on something having to do with CEQA, and my colleague at that time happens to be working on something under the unfair, under the labor code, for example. So when I see her in the hall and I say, hey, what do you think about? She'll say, hum a few bars, because it's not on her mind at that time. So we write back and forth to each other, long memos, short memos, and all memos are of different colors. So I can see one and I know they've read my calendar memo, they've read my analysis. Blue means you now have an analysis of my analysis for me. So the curtain at the Supreme Court is, I would say, heavily graphic. We are always writing each other. We keep a record of the evolution of our thoughts as well, our preliminary drafts before they turn into the ultimate memo. And what I fear is if there were a leak, it would chill our ability to trust each other, testing out our theories, our analyses. We play devil's advocate. We take the side of the brief of the party who would be losing in our court, and we try to vigorously defend it in order to understand if we're truly on the right track. But if I knew that that would be released and that could be perceived as my point of view contextually in a tweet, that I would now be on my heels trying to defend a position I was merely testing, it would seriously undermine our ability to consider all sides. And I can't say enough how we were all just taken aback by the release of the draft. We have at the Supreme Court confidentiality agreements. Everyone signs one, from our clerks to our annuals to our externs, because it fosters rich debate that helps us get to the right place.
And do you have conferences amongst the justices as well, in-person conferences, or are you really communicating mostly by written memos?
We have in-person, we have phone, we try to get people off a golf course on a Sunday in a parking lot because something has come up and we need to rule. With 7 of us, especially the fact that we have spent so much time together around a table in my chamber, we have a great degree of familiarity with each other. We talk and write, but when cases are argued, we meet at lunch and have lunch at my conference table, and we do post-argument conference. Then at the end of the day, we sit at my table again at 4:30 or 5 o'clock, and we have post-argument conference. So we're always sharing where we are, and even it may change from when we last spoke.
There's been a lot written about Justice Antonin Scalia and, of course, Justice Ruth Bader Ginsburg and their friendship. Are there similar types of friendships amongst the California Supreme Court justices?
Yes, there are. You know, a number of our justices have spent some time in Washington, D.C. in different iterations of their professional life, and so they have people in common, and we have a lot of questions of each other. We're different generations. Some have children, some have grandchildren, so we have a lot of really collegial times together with each other.
Excellent. Well, back to Dobbs specifically. You gave us a little bit of a window into your thinking when you noted the evisceration of right that you thought you had growing up. But I'm curious about whether you agree generally with the legal foundation of that recent Supreme Court ruling. Do you think they got it right?
Well, I would like to tell you that I could opine on that. I really can't under our canons and our ethics and any iteration of challenge that comes. But I will say this, as far as I'm concerned. It is the law of the land. I can like it or dislike it. From my position as a judicial officer, I'm not in a place to change it unless smart attorneys bring a case with an analysis that is tested and vetted that changes that. And so understanding the three branches of government, as we all do here, there are other two branches that if they disagree, they can act. But the judiciary would not act in the first instance as a state court.
You also referenced earlier in your remarks, the fact that California Supreme Court justices are chosen in really a fundamentally different way than United States Supreme Court justices. Here, the appointments are made by the governor. The Ginny Commission, as we call it, goes through an extensive vetting process, and then those appointments are regularly or routinely reaffirmed by California voters. I'm curious, though, about your impression about how ideology and politics are affecting the judiciary in California, particularly because the state is predominantly led by Democrats.
Yes, and that's interesting, of course. It is the governor who appoints at the appellate level, both the Court of Appeal and the Supreme Court. An attorney or a judge cannot run for that position. Those positions are hand-selected, then statewide, anonymously evaluated by your peers, and then you go in front of a commission on judicial appointments, which I chair. So ideologically, of course, the governor has his own vetting team and own set of questions. And when I worked for the governor back in the mid-'80s, Governor Duke Majan, that was a process. There was an appointment secretary, and he was selecting candidates based on the beliefs of the governor at that time. And he was called Iron Duke for a reason. And so he had an ideology. And that's been true of every governor since then, actually. And some of the ideologies have not looked at party. For example, Arnold Schwarzenegger, a Republican, picked Dems and Reaps for purposes of judicial appointment. And the same with Governor Brown, that it looked more at experience, balance, judgment, temperament, and written word that they knew that they could find more about the candidate.
Also, with respect to just term limits, there's been some talk of imposing term limits, right, and on a federal level at the U.S. Supreme Court, similar to the limits that are on California Supreme Court justices. Do you think that's a good idea?
Well, I'm only the product of term limits, so I have stood and ran for office numerous times, and I will say that I think there is value. I mean, California has changed radically, right, since I was first appointed in 1990. So the voters have had an opportunity to decide whether they want to keep this judge or justice on a retention election. And as the state changes, and as California has become far more diverse now than it ever was in the 90s, it's important that people have a say as to who it is in the judicial branch. But that's my view. I'm the product of that, and so I can't speak otherwise. I'm sure if my friend from the Ninth Circuit, Judge Connie Callahan, were here, she would defend the process that she was appointed under.
On the topic of how courts influence public policy, right, which is sort of the topic of the day, do you see a greater move in California towards judicial activism?
I have always wondered exactly what is judicial activism. Friends say, well, judicial activism is when you disagree with what the judge said or did. And I don't know that, but I know that if we mean that judges are speaking more and more in dissents or concurrences or in different at the hustings for different speeches about policy, and that they wish to see certain policy addressed, that's true. We'll often write in our opinions at the Supreme Court, by the way, if we got this wrong, the legislature can fix this. Or sometimes we invite them to actively address a point. So I think judges now might be more willing to point out to our sister branches or to the voters where we think there's some confusion, where we think you need to take a look. But I hesitate to think that we put our thumb on the scale and say, write it this way. I don't think that's yet happening.
And just one final question, and it's on a topic that I know is near and dear to your heart. Of course, in recent years, there's been great attention on issues of racial equity and racial justice. I'm curious about how you think our judicial system's doing here in California with respect to the equal provision of justice.
I think in California, honestly, I think we lead. You can't find a more diverse Supreme Court. 7 people, we have majority female, and we have 1 white male and 1 white female, and the rest of us are a collection of different minority groups. But as a result of the governor's appointments and judicial elections, which are few by way of comparison to governor's appointments, we have an incredibly diverse bench. And in fact, in the last 5 years, something like 85% of the appointments in the 9 Bay Area counties have been women.